We should go ahead and get started. So this is, if you're making sure you're in the right place, this is Approaching Culturally Appropriate Justice with Indigent Defendants. So you've seen me before, I'm Sean Watts, I'll be the facilitator. And our presenters are Honorable Michael Smith, who is District Court Judge at the Sac and Fox Nation, and also a guardian ad litem for the Chickasaw Nation. And they also have Eldridge, Coochise, the Chief Justice, retired Chief Justice of the Hopi, and they'll be presenting the material.
For that purpose, do I need to be over there?
Do they need to be in a spot, or can you put a whole frame? Oh, you want them to be over there? This is fine. Yeah.
Well, hello, everyone. I'm Michael Smith. As Sean said, I'm a district judge for the Sac and Fox Nation. I'm a court advocate for the Chickasaw Nation, which is an access to justice program. I teach at the University of Oklahoma Law School as well, tribal courts and indigenous peacemaking. NOU is offering a certificate in peacemaking through their summer program. It's kind of an intense program. It worked out real well this summer. I believe Judge Todd's daughter was in attendance. We sure enjoyed her. And I practice law as well with my sister, Barbara Smith. Many of you know her. She couldn't be here today. She's not doing so well health-wise, but she hopes to be back on her feet in a few weeks. Our topic today is justice for indigent defendants, basically. I've had an opportunity to have some conversations with some of you, and the interesting thing that I've found that anytime you have a conference of this nature, topics come up over and over again with similar variety. In this particular arena, Nora and Tom asked us to kind of review a film in which our group, our breakout group, talked about how to get defendants into a peacemaking court or circle. And quite frankly, I know some tribes make it mandatory. Our tribe at the Chickasaw Nation, Sherry, you might be able to speak about this further, but it has to be voluntary. So, therefore, the first opportunity that you have to get people interested in peacemaking is usually at the courthouse door, because they come to the courthouse already with the anticipation of going to court. And really, it's kind of a diversion offer in our tribe. I know other tribes do it differently. Some mandate, once they have somebody review the case, they think, well, this is a case that has a good opportunity to go to peacemaking. But that's just a different approach. And I think, 566 tribes are probably quite a few different approaches. I was pleased to see how many people there were from so many various nations that were practicing peacemaking in their tribal courts. I was truly surprised. I did not realize that so many tribal governments had worked to establishing peacemaking courts. That was something that I found pretty fascinating. Also, recently I was talking to Sherry, and Sean and I had a conversation about this as well, that what works best for tribal people is probably more of a diversionary style court than it is for incarceration. VAWA, which is a grant of jurisdiction by the federal government to tribes to prosecute non-Indian people that commit Indian domestic violence against Indian people. And it grants you jurisdiction so that you may incarcerate those folks. But just traditionally, I don't think that works very well as a model for Indian governments. I mean, I know there's some people that need to be behind bars, they're criminals, and, their crimes are horrific. But generally speaking, Indian governments have been more about a restorative process. And the restorative process is really about bringing balance back to the community, because the entire community is injured when there's violence or a wrong done in a family or in neighbors or however the community may look at it, because it just doesn't affect those two people. It affects other people that surround them, and they're, as we've heard today, they take sides and they bring those grudges with them to work and to play, and in an Indian community, we see each other quite a bit. In the Sac and Fox Nation, there's only 4,000 people, roughly, maybe a few more, but they're a pretty litigious group, generally speaking, and I don't mean to say that in a negative way. They just believe to use their tribal court to come and resolve their grievances, and they are closely kept people. They work together. They have powwows together. Their funerals they have quite a cultural funeral process. They're very involved in tribal government, and quite frankly, it doesn't really benefit them to have a winner and loser. They need to come to court and try to get some balance back into the community, where people have felt like they have brought their case to court, they've pled their case, and they've been judged. They've had an opportunity, and it's been fair. And that's really what I try to do in the Sac and Fox Nation. And I find, this is about indigent people, this panel. And quite frankly, the void in justice for tribal people is pretty vast. And there's a lot of indigent people that are in that void. I think, though, that for the most part, indigent people, just like anybody else, they want to be heard. And so much of their life, they have not been heard. They're often downtrodden. They've had plenty of people telling them that they're not good enough, they can't do. And really, they just want to be treated with respect when they come to court, like anybody else would. And I don't know that that's always the case in every court setting. I've been a lawyer for a long time now, and I have been to courts where the judge feels like it's appropriate to humiliate and just degrade and really drag them around the courtroom for their deeds. You know what? That has no effect on someone who's been to court 10 times. They're not listening to you. It is water on a duck's back. And really what they would like is for them to be heard, to be treated with respect and dignity. And I let people that come to my court tell their story, whatever it may be, for however long it takes. We don't have the ability to be there all day, generally speaking. We all have, those of you who are judges know that you have a docket and you've got to get through it. So there's got to be some sort of time limitations on it. But that doesn't mean we can't let people talk and tell what their problem is and how they feel about this problem. I try to use some of the skills that I've learned in peacemaking while I'm at the bench, unbeknownst to them. They may know it or they may not know it. But I try to direct them to common ground between parties, because normally these people know each other. And quite frankly, they usually have relationships. If it's a domestic, if they're married, they have lots of common ground. And if they're just neighbors, they've known each other for many years, more than likely. If they work together, the same thing will apply. And we try to set values in our court so that we're not going to, you can talk bad about him and she can talk bad about you, but that's not going to get us anywhere. We really need to see how we're going to reconcile this problem, look for our common ground, and stay with values, because generally speaking, a husband and a wife particularly would not let someone else speak about their spouse the way that they speak about them sometimes. And we try to keep that out of the courtroom and stay focused on what's really important, which is normally the children that are involved. A regular divorce, that's not too complicated, really. But when you have a child involved, that is really the focal point of everybody's attention. And the negative talk, I try to keep out of our proceedings unless it just needs to be done. Unless someone's a really bad actor and I need to know about it. But otherwise, we try to use some of those positive values that we have learned in peacemaking over the years, and I find that to be pretty productive. As a court advocate, I work for the Chickasaws under a contract as a court advocate. And that's an access to justice for people who can't afford to get justice any other way. They come and see me and spend 30 or 40 minutes with me and tell me there's problems, and I draft pleadings for them so they can get into court. I describe the landscape, the legal landscape that lays before them so that they can go to court and understand what's going on. And I just tell them to go in and tell their story. And that seems to work pretty well. We do about, I think the advocate, there's 2 advocates. I would say we probably do around 15 cases per week. 3 half days a week is what I work. And that's a pretty big thing for a tribal government to do for its citizens. Because many of these people that come to see me have never spoken to a lawyer of any kind for any reason. Because that costs money. And most of them don't have money. And this is their time to come. And quite frankly, I let them talk about whatever issue they want to talk about. I don't care if it's a car title or a criminal matter or whatever. We always get back to the point. But this is maybe their one time to talk to a lawyer. And the Chickasaws should be commended for making that possible. I did want to mention Red Hook, and Sean got Barbara and I an opportunity to come out to Columbia Law School, and we had met the folks from Red Hook out in San Diego in a peacemaking conference. And Red Hook is a community in Brooklyn, and the last time we were there, we got to go over, Sean set up an opportunity for us to go over and talk to the folks at Red Hook, and Judge Calabrese, and what he's doing with his diversion program. And he's doing it under a model of indigenous peacemaking. Pretty remarkable what he's done. He's taken an area that's a high crime area, and it's a place where they have tons of public housing. Not a little, a lot. And it's right on the point of this place across from Manhattan, the richest part of New York City. Right across the river is the poorest part of Brooklyn. And the crime rate was horrific. And so he said, I want to try this program here. Well, the Catholic Church gave him a building, and he got some funding from the state, and he found some peacemakers that had been trained. Some of them were students from Columbia, and others had been going to peacemaking conferences. They put together an indigenous peacemaking model that is a diversion program. And for him, he gives people a choice, and quite frankly, the 10,000 people that he has in his little community is a community. That's very diverse. They're not connected except for they live in this one place. But there are all kinds of nationalities, and ages, and differences. And he said, let me have some of the money that we're going to use for incarceration, and we're going to use it for diversionary programs. And I think you'll see a savings at the end. So he started this program, and he's done it now for a few years. I don't think it's very old. But this past year, he saved the state $17 million. And the state of New York has decided to expand this jurisdiction by 15,000, another community, because this is working and these people are getting services for the problems that they have. And as Sean said, some of them need housing, some of them need a job, some of them need a resume, some need, domestic counseling, marriage counseling, whatever they may need. He's providing those services for them, and they're becoming better citizens in their community. It's really restoring balance to a community that had none. This community, police were afraid to go into. When you first got your apartment at the public housing, part of the training was about when you hear gunshots, jump in the bathtub, hit the floor. So it was not a very pleasant place. And he's turned this community around. And still, I'm not saying it doesn't have crime, they still have problems. But he did save $17 million for the state, and that's something governments can be attracted to. Tribal governments don't quite have that problem because they don't deal with so much crime. The Chickasaw Nation, I'm not even sure that, do we have a criminal docket, Sherry?
Do we have what?
A criminal docket?
Dustin has, it's not a dedicated criminal docket, but he does have juvenile.
Juvenile?
Juvenile. And
Juvenile
then
cases.
I have the occasional misdemeanor that's integrated in my just general.
Very minimal.
Yeah.
It's the same way in the Sac and Fox Nation. We don't have a large criminal law. We have a few cases, but that's really not our focus. But I think when it comes to VAWA and trying to assert that jurisdiction over other folks, and that's why I brought it up, is that the diversionary program at Red Hook is working. And I'm not sure that tribal governments want to be in the business of incarcerating people. I just don't, they don't really have a drive to do it. They don't incarcerate a lot of people. Let's face it, before the Europeans came to this continent, I don't believe there was a jail anywhere. Of the many tribes across this nation, I don't believe there were any jails. And if you look back to, and I'll close because I know I can kind of ramble on, I'll close in just a second. But early on, someone asked today, has this ever been used in a murder case? Peacemaking in a murder case, how would that possibly work? Well, you don't have to look far if you're a lawyer and you've taken federal Indian law to understand that Ex parte Crow Dog, which was a Lakota Sioux and a Brule, got in an argument and Crow Dog killed Spotted Tail. It's a complex and a very interesting backstory if you ever want to read it, and you should, because the backstories to these cases are really about people. They don't just stand for little one-liners that you'll learn in federal Indian law. But his sentence for, they formed a tribal council. And there may be some Lakota Sioux here, they may be able to speak about this further. But they formed a tribal council, and the tribal council decided that Crow Dog should pay $600 to the family of Spotted Tail, give him 8 horses and maybe some blankets. And for the rest of his life, he was going to have to take care of that family. Not only his family, but their family too. And that was restoring balance to the community. That's kind of restorative justice, I think, tribal people have been more about since the beginning of time. We need balance in the community, and if you can't live in our community, then perhaps instead of being incarcerated, what they would do is banish you. That was a much worse punishment than incarceration, because where are you going to go? Who are you going to find to be the community with you? But that case in particular came to mind when that gentleman asked about the murder case. Well, I've kind of hopscotched around a lot of different issues. Does anyone have any questions or comments they would like to make? Anything about anything I've said?
No, I just think that with the Violence Against Women's Act, that I think that the federal that's not our goal. And so, I think there was a misperception on the part of the, some of the people behind the reorganization and blah, blah, that, tribal nations are not just rushing to get to be the pilot program.
Yeah, because often, whenever that person does go to jail, who's going to take care of that family,
Right.
right? If there's been some sort of violence against another person, we have two families now that are going to be incapacitated. So that's a difficult thing, and really, we would like to see our community restored. I think that's generally speaking. And when it comes to indigent people, I think they just want to be treated with respect, dignity when they come to court and know that their story has been heard. And then they don't mind being judged. Okay, if there's nothing else, anybody else? Okay, that's about all I have to say. I'll turn it over to this distinguished gentleman across from me.
Do you want to come up, or if you want to stay, I can go up there and push the button for you. I can stand there and push the button for you.
Okay. Do I need to talk out of the finger? Can you guys hear me okay, all three of you?
No, I can't.
Oh, okay.
Could you speak up?
Four.
We could all sit right there.
All right. Thanks, Sean.
Sure.
Well, our topic was traditional peacemaking, the intersection between tribal courts and peacemaking. And by the way, my name is Eldridge. Nobody pronounces, even here in Oklahoma or the Cherokees try to call me Coochise. I said, no. He only had one O, I have two. But in looking at sentencing in essence, when you look at our judicial systems, almost means it's criminal. Because of the word sentencing. If you peacemaking to be working, it needs to get away from the alternative sentencing period. And as you mentioned the PRODOC. So what we're trying to do is look at what is culturally appropriate when you come to indigent defendants. Go ahead. Several things we have to understand. First is the foundation of court authority. How many of you, four here, have a regular tribal court plus a traditional process? Or you all work under the Western Anglo-Saxon type court system?
I think our tribe does both, but only because of the people that are working in the court, it's not something that's set in stone. It's something that happens depending on that specific individual that's in front of us and what's going on.
Okay, so hopefully you have both factors, processes. And to understand what your realm is, if you're going to go the route of outside the formal court process, you still need to understand what your tribal court structure is and what the creation of your tribal courts. We have, most of them are 1934 IRA creations by the Bureau when they said, tribes, you can go and create your own courts. But when you go in the next one, you gotta hurry along. But to understand the authority of your court system, whether you call it a tribal court or just a judicial process, you have to understand the role of judges. And it's not judges in the sense just like Michael here, who's an attorney. It's judges who are going to decide issues of individuals within the court structure. And to carry that out, you need to understand as people in the system, what the law is and what the practice is. Most of your practice is what the concept of peacemaking. Next one. And so the role of the tribal judge is to interpret the law under the Western form of government. The unwritten, the number 2, that the judge needs to understand goes to the heart of what we're trying to talk about, the peacemaking. And there may not be any rules. I'm a Hopi tribal member. Our numbers are a little over 10,000. We have 13 villages. And they're somewhat all autonomous, even in that structure. But when you look at the customary, the unwritten law, I'm from First Mesa, and there's 3 villages there. Most of our process is still not written. 60% of rules that our court system operates under are unwritten. But that's one of the reasons that our court, like many, require that a tribal member has to sit as one of the judges. Because we still operate our whole system under the clans. And I don't know how many tribes here have clans. We have 43 different clans. And they all have different responsibilities. Some of them have the responsibility to be a judge. Others to law enforcement. Whatever it is, each one of those clans determine what their role is. But the practice is how you deal with issues. At Hopi, when I started in 74 or something, our court could not handle children's cases because that was not our jurisdiction. That was to the village leaders, the Gigmoy or the governors of those 13 villages. But if they didn't want to handle it, they had to just on a note say, Judge, we want you to handle it. Just like any tribal community, most times they're all related anyway. So they want somebody that's more independent to look at it. So, go ahead. The history, and Judge brought this up. In 1883, that's when the Crow Dog issue happened. And he went to the Supreme Court, and the Supreme Court said, we don't have jurisdiction. It's their own. So the BIA, through the department, they were under the Department of War then, they created the CFR courts. There is no statutes that operate the CFR courts. It's all regulatory. If you look in 25 CFR for most of the regulations, but there's no statute. The 1921 Snyder Act is a funding mechanism that puts money out to your court systems, no matter how small or how much it is, including those of you who get federal dollars from the Department of Justice, where a lot of these programs go and how to deal with and try to address the issues. The 1934, the Wheeler-Howard Act, actually that's the beginning of most of our tribal courts, as we know. And so when you look at 1934 to, where are we, 2014, that's really not that, we're really not that old. But the only thing that's older than that is our traditional practices. At Hopi, we always had a process. We didn't call it a court, we didn't call it judicial, we just dealt with the issue, and generally it was the head of the village and the individuals who had responsibility of different clans. They get together and handle the issue, a solution. In 1968, of course, we got the Civil Rights Act, and then it was changed 2010, and that's where your Tribal Law and Order Act came into being. Next one. Santa Clara versus Martinez is actually dealing with enrollment issues. Who can be members, who determines, but it's a tribe that determines its membership, not an outside entity. Now, the Bill of Rights is applicable to all of us. It doesn't matter what you're doing. If you're sitting as an arbitrator, if you're sitting as a peacemaker, or a judge in a criminal setting, all these rights are applicable to you. A lot of tribes have their own Bill of Rights. In the Northwest, where I retired from, that was a big issue because of their fishing, their salmon. And certain people had rights to fish. There were the Yakima, Warm Springs, and Nez Perce. A lot of times they fished at the same location, but at different times. But it all fell under the tribe's Bill of Rights. Nobody could just go and fish there. It was a system that was in place. Now, tribal courts are created by tribal legislative bodies, or more recently, in the last 10 years, you're seeing constitutional courts that are voted on by the people under that community, whether they're all tribal members or people who live within the jurisdiction of the tribe. Judges are still either appointed or elected. So there's pros and cons to either one of them. And in every case, no matter what you're dealing with, you have to address the three jurisdiction issues. If you have personal jurisdiction, is it over members? Is it over non-Indians? Or who it is? And of course, the territorial, which is easy to understand, generally is within the boundaries of our reservations, whether you're solid or whether you're checkerboarded, like a lot of the Midwest northern plains.
Yeah.
But the one that's important is the subject matter. Before I retired in '97, about 2 years before that, one of our judges, I was head of the Northwest Intertribal Court System, took on a child's case to transfer from the state to the tribe. Well, I got called on the carpet. Said, Judge, who authorized the judge to transfer that case from the state? I said, well, I didn't. Because what the council, when I go before them, said, we did not authorize the court system to take jurisdiction of those type of cases, the children's cases, even though it's important. But when you live in the Northwest, usually salmon fishing is more important than kids. But you don't have a subject matter jurisdiction. Just like at Hopi, when I took the bench, we didn't have subject matter jurisdiction over children. In our Constitution, it said it's up to the village, the king, or the governor. And there are a lot of tribes that don't give you, in the court system, the jurisdiction you may need or you want. So we have to be mindful of all of those. When we talk about tribes and dealing with who we are and the sovereignty, one of the things that in doing research and running on the Hill for 18 years for funding for courts, so this was a simple definition of what sovereignty meant. It's the power of American Indian tribes to make their own laws and to be governed by them. Unlike the Congress, they make the laws, but they don't have to be governed by it. And a lot of states are in the same boat. And then the right tribes have control over their lands and the people who come onto those reservations. Except that was hammered in the Oliphant case and said, even if they're on your reservation, you don't have jurisdiction over non-Indians in criminal cases. And the right of tribes to control their own resources and destiny as a separate people and sovereign. And that's what the tribes have been trying to do for a lot of years, and they still go And the last big act, of course, was the TLOA, and then the VAWA got reinstated. But it's basically giving the tribes, how do we want to deal with it? Let us, we are sovereign, we can handle it. Next one. The authority that we currently have, here's a few of them that's going to affect the peacemaking as well as the formal court process. Certainly TLOA, and you mentioned, Bob, that's not really working. Well, the problem with TLOA is if it's tribal members, it takes money. And the indigent people don't have that money. And right now I'm finding, following my own tribe, we have more Hopis in federal prison now because of child sexual abuse that wasn't there for a number of years because of TLOA. Hopi is really a traditional tribe, so I was really surprised when they passed a new law and order code addressing TLOA. And they went to change the structure, all the chief judge, and they put in another called senior judge. They had to all be attorneys. The associate judge is still the one that has to be a member of the tribe itself to deal with these issues. Now, the federal regulations, even if you have an issue that comes before you in the court, generally the federal CFR goes to the federal system. But that's not necessarily the case because the Bureau does not always want to handle it. Even probate. Well, you're supposed to go to them, or they'll just say, no, you guys handle it, and we'll come and rubber stamp it. So you're involved in that, policies, the rules that the tribes make, but the tribal rules and policies are generally unwritten. You can go through research, and there's no, because each of the 558 tribes that are federally recognized have their own rules under which they play. And so you have to understand it. When I first went to the Northwest in 1981 as a chief judge, it took me 2 weeks to go through all 15 tribes that were in the system, trying to understand what their codes dealt with, what the child issues were back then. But the biggest factor I understand that no one wrote anywhere is who can fish and who can go out hunting. I got really embarrassed the first year I was up there because I went to a tribal council meeting just to visit with them. And there was an old gentleman sitting here. Everybody called him Uncle Joe. So I asked him, I said, where can I go fishing? He said, what do you fish for? Trout? That's the only thing I ever knew. He got up in the middle of top of the voice. You want to what? Trout? That's garbage. Here, it's salmon. Don't ever talk about fishing if it's not salmon, because all the others, trout, all those other fish, they're garbage. So I had to quickly learn what their rules were and policies that were not written. And that was shortly after the Washington case came down, and that's really how the Northwest Intertribal Court System came into being, because Judge Bolton said, okay, tribes, you guys can have jurisdiction over your hunting and fishing, and then subject matters added up. 280 regulations, and certainly the contracts, mutual understandings, agreements, those are authorities and land laws that you have to deal with, whether it's in the formal process or an informal process. So when you look at this, I've been teaching at the Judicial College Reno for I think about 16, 17 years. And the state judges say, how can you handle court? We only have one state law and system. You got many, then you have to understand the federal statutes, the CFR court, and then the tribal rule, you got 3 different. So which, I said, we just have to study more than you guys do. You guys went to law school. We've got lawyers in tribal courts, but no law school teaches tribal jurisdiction. Just the one in New Mexico, it's general. But this is what we're up against with trying to deal with the term peacemaking. At Hopi, we never called it peacemaking. We just called it a process to undo or fix a wrong and to make sure that the victim got his, I don't like to use day in court, but got his system. Because a lot of times people would break potteries and then they had to powder the paper. Well, most of Hopis, except me, know how to make pottery, so they have to go do it. Or I'm a cattleman. I've had cattle that were butchered and stolen, and when we find out, we just go to the village. And the group, the Gate Moment and his group that handles stuff, they set everybody down. And in that process, everybody has to say when they sit down to deal with it. Even if you don't have you're not a party of interest. In that traditional process, everybody has to say. And it goes back to part of the community. How are we going to make that work for community members so that it doesn't keep happening? Then when it goes to other tribes, like our neighbors Navajo, they steal our cattle, and that's dealt more in the formal process. So, next one. So now what we're looking at, and we've got asked to deal with, what is culturally appropriate justice? There are probably 558 different versions of what's culturally appropriate. And what are those in your tribal systems? We talked a little bit about it up in your North Dakota, right?
Yeah.
What system do you have up there?
It's just the general court. You know, if there's something that we do that's like what you call a traditional type thing, it's because it's something that happens during court, and we just move into that area. So,
Yeah, one thing that we deal with, a lot of the big tribes in their traditional process, is religious artifacts or religious items that are given to certain people to be responsible. I know when I was in the Northwest, at Warm Springs in Yakima, there was a divorce between a man and a lady from those 2 tribes. Well, the court, being more of a Westerns, divided that religious item that didn't belong to the individual and gave it to a Navajo tribal member. And I said, wait a minute. I got called in and said, religious artifacts are generally dealt with by the religious groups, the clans, and like in New Mexico, they have those Lincoln, what do you call them? Sticks or something. The 19 Pueblos have one in each one. Somebody has authorization and control. So if you go in the civil process, you can't probate that to non-individuals who don't have a role. I'm a member of the state plan at Hopi. If it's dealing with some of our issues, we call it deep money. And at Hopi, somebody has control. If that person dies, it goes to the next one that's in line. It is not part of that family or their family to deal with. And so when you're looking at what are the justice systems, you're dealing with a lot of issues that are unclear. But you have to make that determination. I've been on for 6 years now, an arbitration, one of the commissioners between the Hopi and Navajo on equal issues. How are you going to deal with it at each tribe? They set up the commission. There's 2 of us from Hopi, 2 from Navajo, and 1 retired state judge. And we deal with it so it doesn't have to go to a federal court. But you have to understand what's the process at Navajo, what's the process at Hopi, who has the authority or the responsibility. Hopis gather eagles from Navajo land. And how do they do that? Who gives it? And one thing we need to remember, the traditional process predates the 34 courts that we're aware of. At Hopi, as long as I remember growing up, they used to take me to Cuba and you know, I could barely sit up and I told them they were brainwashing me. But that's how we learn what our roles were. What's my role as a snake clan member? When I first got asked to go on the bench, my family, my aunties, they all said, no, you can't do that. Your role in our society is not to sit in judgment of other people. Our chairman, who understand at that time, Abbott Sikipo, understood the roles, and so he came to our village, to our clan, and said, well, we need somebody who can at least handle the court process, understanding it, but we need to get your okay so that he could sit, so I could appoint him. So when you have roles that don't fit, generally somebody has to authorize that. I sat for 7 years at home, and then I went to the Northwest. And I didn't know how it was sort of much easier to sit in somebody else's court instead of my own. And I learned later when I retired, they asked me to come back and sit in it. And my mom was still alive, and she said, no. She went, my aunts, they gathered one evening, all of them, and they told me everything that they had to go through for me sitting on the bench at Hopi. Basically the torture, the being chastised by community members because of what I did. And so when you look at, and Michael's right, I don't want to call him Michael.
Yeah, that's fine.
You look at what is your role and how does it affect your family. That's one of the traditional processes. You don't just go apply for a job. That's not the way. I never have applied for any judgeship I've been at. I always got asked to do it. But I didn't realize how hard it was for my family, my immediate clan members, and my aunts and uncles, because they took the heat for what actions I did from the bench, both in the formal and the informal process. So when you get talking about culturally appropriate, you have to understand, especially if you're not a member from that tribe, best thing you have to do is take 2 solid weeks and try to talk to people, the elders, and say, what happens when this occurs? What happens when these children? What happens in, because it won't be for until probably 15, there was no such thing as divorces. Once you got married, you were married for life. And so you had to understand it. Well, we had judges come in and say, yeah, we're going to, wait a minute. Hopi, at the time I was sitting there, said, did not have divorce jurisdiction because of the realm that there was no such thing as divorce in Hopi country. And so you try to work it out, and because I think there are all, maybe there's one that, a lot of those pre-dated marriages were chosen by their families, not by the individuals. So since you didn't have a say in getting married, you don't have a say to get divorced. And that's the way the tradition went. It was just in recent years that they did divorce, and that was a week and a half ago I got a call. Two people, Hopis, wanted to, they file a joint dissolution of marriage petition. The new judge, who's the senior judge, and I understand he's Hopi or he's not Hopi, said, I'm sorry, can't dismiss lack of jurisdiction. You guys aren't residents. And the lady and the guy, I know both of them, said, what do you mean you don't have jurisdiction? So I called the tribal and got a copy of the civil code. So I told him, I said, well, you need to go back because there is no residency requirements to file a civil action, and a marriage dissolution is a civil action. Plus, at Hopi, we are permanent residents of our reservations. So you can't say we're not. They lived in Page because of their jobs. It's crazy to go from Hopi up to Page every day to go to your job. They both have homes. One's in the Monkobe village way in the end, and then the one's at Hopeville, and then they have property at both places. I said, because the judge said, well, you go to state court. A state court can't come in and probate any of those issues, even the housing. Most of the housing, unless they build, are HUD housing. But they're built on clan land. So from Hopeville to First Mesa, they can't just come over here and build a house because it's controlled by the clan of each tribe. And so you can't walk in and say, well, then build a house. It's not going to happen. That's the tradition you have to learn. Go ahead.
I think it depends on the story you hear. What happens in court. Like in the civil area, like for our tribe, like adoptions. I'm not talking about the kind that they talk about when you're adults, you take somebody as a brother or a sister and embrace them. I'm talking about an actual adoption of babies. A long time ago, like if there was a couple that had a lot of babies, they couldn't handle them all. They'd look and they'd find someone that was childless, they'd give them babies. Here, this is yours. And they'd be raised by that family. Like we had a situation in court maybe 4 years ago where this woman was trying to get her daughter scholarship for school from the tribe, but she was having trouble with the enrollment process. And here when she went back, and she knew all about this, but she didn't know it was all messed up. When she was born, she had 5 siblings that were older. They were all like this though, almost all in diapers. And her mother was dying from childbirth. And so her mother talked to her dad, and they had friends that were childless. So he went and got them. And on her deathbed, she gave that child, with the father's consent, to that couple, yours to raise. She's about my age. And we went, and there was a problem with enrollment. They couldn't get your daughter or granddaughter scholarships and stuff, so we had to straighten out the birth certificate, the enrollment, all of that. And so the nurses that were in the hospital that day, when it happened, they were still living in their 80s. So they brought them into court, they told their story, and I talked to them. And I knew all about it already. I knew that was something that happened, but I had to have a record of it in court. And I asked them, well, and they're both Indian nurses too. And I asked them, well, did you see this happen before? Oh yeah, it happened all the time, they were saying, like in court, always happened. I have relatives that were given to another family. I know who they are. They were raised by that other family. And we know that that's their children. It was common. And so what we did eventually was we issued an order, and we acknowledge the biological parents, and we acknowledge the adoptive parents, and we declare this adoption non-proton from back. And then they sent the order to the state. The state actually issued a birth certificate with all 4 parents' names on it. And then we got her properly enrolled, because they didn't enroll her.
Yeah.
See, that's what happened. So we got her properly enrolled, and they got all those records straightened out from that one court order. And that was like a custom type thing. And so, you know, you might have a regular adoption that might be held through child welfare because the parents' rights were terminated and went through that whole white man process. But when you have a traditional one, it's much more stable. It fits better, you know, because everybody acknowledges it. It's not something that's forced. The biological parents have a say in where that adoption goes. But if you go through like child welfare and child protection services and all that, they don't have that process where a family might be able to say, well, we know that these parents are incapable of taking care of this child, so therefore we have a part in the process of designating who we think is a good family to care for that child. See, that's restorative. Instead of the process that they have like mandated by child welfare, where you have 18 months, you have all these requirements you have to fulfill, you have to go to parenting, you have to do this, you have to get alcohol and drug evaluation treatment, take care of all your criminal requirements, bang, 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 all the way down. These people lose their housing because of drugs, they lose their whole life changes because they've lost everything, including their children. And they've got to fulfill all these requirements. And these people are all in the system, and they're just doing their 8 to 4:30 job. You know, and these people are being negatively, it's just overwhelming. And it's destroying our communities, and we need to get that type of, I've been trying hard, and we do have that stuff happening, but it's not because we have a system in place that's like an alternative type thing. It's because of the story that's told in court, and it just moves in that direction naturally. See what I'm trying to say? So I don't know, that's why, you know, I was just going to come Wednesday, Thursday, Friday, that's why I came this early one, because I need to visit with people about that type of stuff.
Yeah, and that's the same thing that happens in my tribe. It's the village head, the governor, or the king. King is the traditional, the more modern is called governors. They can basically, I don't like the term adopt, they can move a child from one, and even if you formally get a termination under the current VAWA and all this other, it does not break the tie between the biological and the new parents.
Yeah.
And when you live in communities, and so when you deal with that kind of issue, you have to understand that it's not going to be totally 100% severing of ties. In my tribe, one another reason why it can't is because of the clan. The clanship comes through the female. So if that child is from that clan, it doesn't change like my clan, the snake, and my dad's clan. Even if they got adopted by another, their clans
Still
stays. And anything they get, houses, land use, is still going to come through the clan process, not through a formal process. And so that's why I say you have to understand what is the practice, and even though it's unwritten. When I went to the Northwest, I went to as many senior luncheons as I could so I could figure out who these people were and what they were about. Because I got to eat a lot of good salmon.
Yeah.
But the traditional process, in fact, I'll tell you what happened to me. In 1976, I drafted a divorce ordinance to be looked at by the tribal council. As soon as I did, I got called before the council for 2 days. It was nice, but I got chewed out. He said, you can't do that because the elders that were on the council, there's no such thing as divorce. And we're not going to grant it because that's not our way. And like I said, until recently, it was after I'd gone and, see, I've been retired for 16 years now. They have ordinance now that deal with divorces. Everything changes. But, like I said, I thought I was doing good, just like our judge when she transferred the kid from Washington State to Toledo tribe. She said, well, we have to do something. I said, but you don't have subject matter jurisdiction. You know that. No, but the state wasn't doing anything. Well, that's something that the councils have to look at. How do we deal with so we understand and help our people? And Michael brought up restorative justice. I always just say, in traditional justice system has always been a resolution oriented. Too bad you don't have it. I used to teach, and so if you look at the Western type of court system, I always call them, for lack of a better word, a state-owned court system. Their process is once things filed, and then there's middle ground where the attorneys can play ball. And it doesn't matter what happens, somebody's going to be a winner or loser. In our traditional process, if something happens, it's always focused on a result-oriented, so that both parties or the community, that the resolution occurs and that they can live with it. And so when you've got two different types of systems in place, and most of you guys go to school, all you hear is Western Anglo-Saxon law. And a lot of what is brought up here, it still has to be, because even if you made a decision in the traditional sense, maybe one of those parties can, and it's happened before, so we're going to go back to court because we didn't think we got a fair shake. And then maybe nothing more than that. And so you have to be mindful of the rights and which of the rights are you working under? Is it the federal? Is it this tribal? And in one of my sessions I used to teach, I put together just a short comparison chart on the rights under the U.S. Bill of Rights and the Indian Civil Rights Act. And there are basically four different differences. Of course, the first one is U.S. Constitution, you can't establish state religion. Well, the Pueblos fought, and so under the Indian Civil Rights Act, tribes can have a tribal religion. Most of the tribes usually have one overall religion, and so they can establish that. And the other is in grand jury. Under the Indian Civil Rights Act, there is no such thing as a grand jury. A lot of courts are starting to adopt it, tribes are putting into place now. And then the due process issue, speedy trial notice. You have a right to a speedy trial notice, that right. However, it's at your own expenses under Indian Civil Rights Act. Otherwise, the tribe won't pay for your rights under that. And the excessive bail under the right to jury trial. Under Indian Civil Rights, it's 6 persons. Under the federal and the state, it's 12 people. Those are three of the differences. And the other is the penalty. In the Indian Civil Rights Act, we now have, it used to only be 6 months, and then it changed in 1986 to 1 year and $5,000 because of the war on drugs. Then in 2010, it changed with TLA to 3 years in jail and $15,000 for both. So that's a difference in the Tribal Indian Civil Rights Act as opposed to the U.S. Constitution. And those are the differences. That's why I said, I brought it, we need to understand what rights or process we're using. And I found in the Northwest, my counterparts, when I sat on appeals, were usually non-Indian attorneys. They seem to have a better grasp of that process than my counter-tribal judges who were also attorneys. I don't know if they took more time to understand what tribes were about and what they could do as create. And one of the things that they mentioned to me when in our annual meeting one time, it's good to work with tribes because you're actually in the process of making law. If you work only in the state, it's already there, so everything has to go by what's already printed. Tribes, you have openness to creating new law. That issue, I think, is going to come to more of putting that back, or at least creating a rule that will function. And the only reason I put together the divorce ordinances because our young people were going to town hall, boarding schools, and college, and how are they going to understand it if they don't live there? And that was one of the main reasons why I did it. But then the council, and I understood where they're coming from, that's not what we do. And the chairman asked, Judge, who's going to interpret this law if we pass it? Nobody said anything except our two white attorneys in the back said, we are. And we're going to interpret it under the state and U.S. concept because most states have divorce, and we're going to interpret it under those concepts, not under Hopi concept. So when you're talking about, especially you or children, it's really critical, and it gets away from the issue of alternative sentencing, because the formal court process is a punishment. This informal process, a lot of it, everybody's picking up on the words peacemaking. And then my colleague at NAO said, you shouldn't call it that because it's not what's going to work for you. Just because NAO has it, don't pick it up. It's not going to work for you because we all have different ways that we deal with it. And it's traditional is to restore, as the judge said, the victims. Generally, in the formal process, the victim is not even considered. It's the government that gets the money to pay for those. But the biggest thing, again, as the judge mentioned, is to bring peace to the community, to the parties, because they have to live with each other. And when you say community, we're all interrelated. So if there's friction, it affects everybody. And then bring a resolution to the issue, whether it's a children's case, whether it's even a criminal case. Resolve it. TLOA doesn't resolve. I'm sorry, I've been following for the last couple of years. And we got more Hopis in the state penitentiary down in southern Arizona than we ever had. Before that, they work with them and say, okay, this is what you committed on child. Now you, like you mentioned, basically what Crow got. you had responsibility to take care and make sure that that family was taken care of. And it's really set up to fix a wrong and to resolve a dispute.
Just like in law, Tribal Law and Order Act, the ones that are pushing it are non-Indian attorneys.
Yeah.
The Indian attorneys, people in our justice system, people that work for probation, the general population, absolutely doesn't want it. What they want is they want to have our court system have jurisdiction over everybody that commits a crime within our area, regardless of what their qualifications are as in the positions they're placed. And our tribal people have a very hard time wrapping their head around the type of punishment that's authorized through the Tribal Law and Order Act. You know, if it's something real severe, the feds are already going to take it anyway.
Yeah.
They're going to take jurisdiction. We're not a public law 280 state. We have a different type of jurisdiction.
Yeah, that's,
going up.
I'm disappointed with implementing of TLOA. Because for years, we in the tribal judicial system have been saying, hey, we need more resources.
Yeah.
But once they, like Hopi, they ramped onto TLOA, judge's salaries went to 130,000, the new associate 100,000, and the associate judge still at 50. That was another reason I left Hopi. I was working for 10,000 a year, and I asked for a raise to 1,000. They said no. So I said, okay, I got a call from the Northwest. They offered me 75,000 a year, and I said, might as well go see what's wet country's like. But now, the people that are pushing TLOA, and they get them out and they're in prisons, they don't participate in their traditional religious practices. None of us are perfect, but we still have the rule of thumb to practice our religion, no matter what we carry on our back.
Yeah.
And that's not allowed when you haul them off. So, go ahead to the next one. This is the more, and we've got 10 minutes. What I'm going to focus on is the discussion. I know there's only 4 of you here, well 5 of you, Michael. But what do you have at your tribal setting? Meaning the types of cases. Certainly criminal is one, otherwise you wouldn't use alternative sentencing. I don't care for that term because it connotates too much criminal. You got civil, the children's case, the divorces, the land issue. And in the Northwest and the Midwest, tribal hunting and fishing is bigger than anything. Land issues, very few of us tribes have ownership of land. If you do, it's under the Allotment Act. At Hopi, most of ours is tribal land. But everybody has usage under the clan process. And who controls? Who determines whether this person can build a home even if they're a clan member? It goes through several phases. Not just say, okay, you're a clan member, so go ahead. But the feds even today won't pay for your housing. I asked for housing even after retired. They said, no, we make too much money. I said, I made, but I didn't have it. I retired from the tribal courts. But the one thing you need to look at, tribal responsibility. Who has that to make any process work? Is it left up to the chairman? Is it left up to the council? Or is it left up to other individuals or groups within the tribal structure? At Hopi, the chairman really doesn't have that much authority. The council does, and the village leaders, the people or governors, they have the authority. And then even the authorization has to go through the clan. And even housing issues, when it first came up, my sisters applied for it, they're both on it. And they said, well, you can pay it off, or you'll get the deed. that house. Well, my sisters paid their house off 20 years ago, and they still haven't paid the deed. So those are issues that we're going to deal with in the formal process or informal process. The one thing that we need to remember is what are we doing, and it's not against tribal policy. I don't mean written policy. I mean the tribe's rules under which we work. And most, like Hopi, it's still 60% unwritten rules, including where you can have a cornfield, where you can run your cattle. You can't have them in the villages. And you can't have activities during the time that the religious dances are taking place on the mesas. Those are all policies of the tribal communities. They're not written anywhere. I play music on the side. I've been playing music for 40 years. And I got asked to play for a dance last month, second week in September. So I went out there and said, can you do it? The chief one came down and said, no, you can't have it because there's still ceremonies going on. And nobody objected because that's the norm. The tribal practices take place. They take priority. And even school functions. If it's happening during the time, that time our religious, basically our kachina starts, generally in the January through April, into July, and then the kachina's going back. So that ends there, and then they have social dances. But each one of the authority people are at the 13 villages, and they just have to look at what's for the people, and then look at there are children, so they try to make it work. And that's all we're trying to look at. And that's why I said I really don't care for alternative sentencing because it only connotates criminal. What about civil ownership? In fact, I got a friend of mine, my former drummer. His family's fighting over probate. Their mother just passed away. They want to take it to court. I said, I don't think you can. They wanted to go to the county court because they all live in Camp Verde and Flagstaff. I said, the state can't go in there and probate the house, the land, the cornfields, and the pits where you cook your corn. It has to be in a tribal setting. And you need to find out whether the village head is to deal with it. Any dispute between villages doesn't go to court. It stays within the village. If they can't work it out, then it has to go to council. And so when you look at how do you deal with the process, I don't know what to call it, but I haven't bought into the peacemaking because the term just doesn't quite fit the whole category that you're trying to deal with. It's more a resolution oriented that's been the process in most of the tribes. And most of them, if you ask them, well, we don't know, and something happens. That's how I found out in Northwest. Nobody knows. Sit down, Delaware says, what the heck when this happened? Or when somebody's fishing here. Oh, then they can explain how you deal with it. Do you go to court? Some of the tribes still didn't have codes that dealt with it either. And when you got 3 different tribes who fish from the same spot, just at different times of the year, you have to know when those seasons are for those tribal members from those 3 tribes. And one of the ones I had to arbitrate, again, when they probated, the judge gave one of the religious artifacts to the man that it was not his responsibility, it was in the woman's family and clan for that long. So when you look at those types of issues. Just some ideas now. You mentioned several things. What other issues do you have at your tribe under the court process?
Other issues other than criminal and civil cases, or?
Yeah, most of what is there, about 180 tribal court systems now. When I started running the hill, there were 70. The Indian Tribal Justice Act that got passed was my numbers that I put together for running on the hill. But that's only 70, one judge court with a court clerk and the part-time appellate judge. And since then, it's not even, and we still haven't got any of that 50.4 million. None of it. To help tribes. Do you have anything that you're aware of in the, where you're from?
We don't actually. We were not recently, in 1980, we were restored and had appealed to a provision in our restoration legislation. So,
Where are you from?
Southern Paiute. Southern Paiute in Cedar City, Utah. So all of our civil, criminal, everything is.
Is that the Paiute that's up north, on the north end of the river? Navajo?
No, we're a little further north than that.
Oh, okay.
We're central Utah through St. George.
Okay. I know there's a Paiute there that
Yeah.
just got the land recognized from the Navajo
Oh,
Nation.
San Juan.
Huh?
San Juan, Southern.
Okay. But those are types of things, and like I said, I didn't mind, in fact, I still don't mind sitting on it. I learned so much about eagles that I never knew, because it's not my plan. But it was interesting, because the Bennett freeze that occurred, it was always in federal court. Nothing got resolved, and they finally said, you guys come up with a mechanism to deal with your issues. And the 5 of us who served as commissioners were basically arbitrators, or individuals would say, well, what is it? And you have both sides that help you out in that. It's getting a little sticky when the attorneys get involved. But if you got the local people come in and say, well, this is how we did it. In fact, the last, Joe Shirley was now president in 2009 when we had a big one. And he said, this is the way we dealt with it from tribe to tribe, our communities. So why are you trying to add new things? Let's work it out. He said, we wanted this set up so we could undo 200 years of federal rule. Let the people work it out. And that's really what the traditional process means, is to have the people that are there, they can work it out, with or without money reason. The last close friend of mine is an attorney, and he went to a village where they were handling a children's case. They wouldn't let him in. Said, we don't allow attorneys in our hearings. But it's even in state, they don't let attorneys in the lower level if they're trying to work it out among the people who are in dispute.
It gets really complicated when you got attorneys involved in issues that can be resolved with local thought process support and everything. What I've done before, I've recognized that, to clear the courtroom, just the families involved, put them in there, have the attorneys as moderators, shut the door and say, call me when you're done.
Yeah.
And they've done it, and the attorneys are
It
just
is
like,
usually the
"It's
fastest way to
because
get it
that's not a
resolved."
process." I said, well, that's my process.
And that's what we're seeing. It's a resolution process, whether you call it peacemaking, informal court process. It's how you resolve the issue.
Yeah.
The formal court is not set up to resolve it.
Yeah.
It's to see who's a winner and a loser. And it's the government who collects, not the victims. If they're due, there have been damage in both monetary or products, it's the government that benefits from it, not the
And I
individual.
think the outcome, you have attorneys that might be involved, but kind of grateful. I surprise them, like judges get crazy, you know. I surprise them, once they go through that process, and I tell them, okay, I want the two of you to draft something for me. And I want it to be good, and I want it to be sensitive to what these families want. They'll draft something, and I think they're more or less relieved, because they went through that process, and it's a lot easier than being adversarial, and they have to work something out and enforce it in order to do it.
Okay, it's 3 o'clock, so anybody got any other questions, or Sean will get chewed out for running long. I really thank you folks for your comments and, because you're all working in the system. I've been retired for 16 years, but I would not say to you guys, work to get retired. It is boring.
Well, we still hear about you in Delbert, and every once in a while we hear one of your CDs playing, even in the courthouse. So your voice is heard over there all the time. You got
Well, thank you very much, folks.
Clerks like your music.
I didn't think you should sleep, did I, Judge?
No, not at all.
Okay.